So, medical personnel exempt from biometric privacy law. Illinois Supreme Court rules. Of course they did. This is why I want I don't, and I know there's no president that'll remove these judges or could, but I don't really know. I'm sick of it. I really am. The judges align with hospital associations. They always do. They never align with the everyday people. Nobody stands a chance up against these people. And they don't, none of the courts seem to just stick strictly to the Constitution. They find all these ways where it's okay to violate our rights. And this is a perfect example. The Illinois Supreme Court on Thursday ruled that the state's strongest in the nation biometric information privacy law does have an exemption. Healthcare workers who use fingerprints or similar scans to access things like medication, materials, or patient health information. There was an easier way to do this. Really, there was, than having to do the fingerprint. And every nurse is used to it. To get into the Pyxis or an Omnicell, which is what they keep the drugs in, you have to put your fingerprint on. The problem is it goes too far. Then we have the fingerprint to punch in. Then we have cameras that do facial recognition. So the courts are just a waste of time. They are part of destroying our country. And I just, if you're going to disregard the everyday people having a right that you don't have a right to do this to us, then I don't think judges like this should be on the court. I wish there was a way we can just change all this. I really do. Because I don't think how can you make America great again and go back to the original Constitution if these judges are going to align with dirt bags that are all about greed and knowing all of your information? The people I trust the least in this country is any university or hospital administration having any of my biometric data. But in order for me to earn a living, I have to allow them to violate me. In a unanimous opinion, the justices ruled against a pair of nurses who sued their employers over their use of fingerprint-enabled medication storage, a technology many hospitals have adopted to curb abuse or theft. There was an easier way to do this. They wanted to get all your information. The nurses alleged their hospital's use of these medicine cabinets violated Illinois' Biometric Information Privacy Act by not properly notifying them or their colleagues when their fingerprints were collected and stored. But the hospitals maintained the biometric information has a built-in exemption for the collection, use, and storage of biometric information needed for healthcare treatment, payment operations under the federal health insurance, under HIPAA. Writing to his colleagues, Justice David Overstreet sided with the hospitals. Of course he did, citing the law's plain language. No, you don't understand the Constitution. Should anybody like this be on the court? No. He wants to say it's the law's plain language. No law should supersede our constitutional rights, should they? I don't think so. Citing the law's plain language, exemption to healthcare workers, biometric information being used to permit access to medication dispensing stations for patient care. So see, that's a law. If there's a law obviously in place in Illinois, that violates the Constitution and our privacy rights under the Constitution. So that law should automatically be. These judges that are going to do this, I'm just sick of it. In oral arguments in front of the court in September, the nurse's attorney, Jim Zoris, claimed siding with the hospitals would mean the General Assembly decided that as much as 10% of the Illinois workforce should have no biometric privacy protection whatsoever simply by virtue of working in healthcare. He's right. But the court's opinion countered that claim. Yeah, but the court's opinion shows that they're stupid. Yeah, because they disregard the Constitution. We are not construing the language at issue as broad categorical exclusion of biometric identifiers taken from healthcare workers, the judge wrote. Here, the nurse's biometric information, as alleged in the complaints, was collected, used, and stored to access medication and medical supplies and treatments for patients, and is excluded from coverage under the Act because it is information collected, used, and stored for healthcare treatments, payments, or operations under HIPAA. While an appellate court had sided with the nurses, the Supreme Court reversed the decision, agreeing with the circuit court judge's original finding. The Illinois Health and Hospital Association, okay, The Illinois Health and Hospital Association. That's why I bring up all these associations in healthcare. They are part of the problem. They disgrace this country. They hate our Constitution. They hate it, hate it, hate it, because they want to violate nurses. They want to violate this country. They want to overthrow it and push their socialist system in. So of course they'd be against it. God forbid you have any privacy rights. The Illinois Health and Hospital Association, which filed an amicus brief in the case, praised the court's ruling on Thursday. Today's decision correctly interprets that the legislature intended an exemption for biometric information when it is being used for treatment. Oh, go screw yourself, Hospital Association. You know, the mere fact that you think, oh, well, this is in the law. No, it violates the Constitution. We are constantly have our rights, our right to privacy being violated. There's other ways they could have made things safe so that there's not drug diversion. They did this biometric shit on purpose. I'm not even going to read the rest of what they say because they use the word care, and no association in healthcare, nursing, medical, none of them, hospital, should ever use that word. They don't know what it means. Thursday's opinion is a departure from the court's recent rulings in other cases related to biometric information, the law that allows individual customers and employees to sue businesses that don't properly disclose the collection or storage of information like fingerprint, face, eye, and voice scans. Biometric information related litigation has exploded in the last several years as the widespread adoption of scanning technology has caught up to concepts envisioned in the 2008 law in Illinois. Since roughly 2018, upwards of 2,000 suits have been filed under the biometric information, followed by several high-profile, high-dollar settlements, including $650 million class action settlement with Facebook in 2020. The social media giant paid more than 1 million Illinoisans over $400 each. Earlier this year, the state's high court issued 2 rulings strengthening the biometric information. The first case, a unanimous majority found the law unequivocally provided a 5-year statute of limitations on lawsuits against companies that collected biometric data information. 2 weeks later, a divided court ruled that each time a person's biometric data is collected constitutes a separate violation of biometric information, which under the law means $1,000 in damages for negligent violations, or $5,000 for reckless or intentional violations. However, the court didn't address how damages can accrue under this, meaning it's still unclear whether each violation means another 1,000 or 5,000 can be added to calculate a total for damages. Last year, in the first jury trial test of the law, a federal jury granted $228 million in damages in a class action case against BNSF Railways, but the railroad was granted a new trial this summer, wiping out the award. Yeah, that's how corrupt our justice system is. BNSF ultimately settled the case in September. All of those developments have sparked lobbying efforts. That's why we need to get rid of lobbying too. Sparked lobbying efforts from industry groups representing business interests, which have been pushing for amendments to, it's just bullshit, all of this. Negotiations to possible reopen of the biometric information to address the High Court's February rulings fell apart during the final weeks of the General Assembly's spring legislation session in May. So you know what? As long as we, the people that don't have all the money that these nursing, medical, and hospital associations have, then it would be good to have a justice system that took that into account and didn't let these damn lawyers that work for these hospitals that are screwing this country over, that are overthrowing this country, trying to bring in their socialist corporate agenda. If the courts really stood with our Constitution in America, then they should start acting like it and show it. Otherwise, they need to go.